All right. So now we are going to talk about the healthcare power of attorney for the signing video series. So this is a two-part document. The first part is going to be the part that you name your agent to make healthcare decisions for you. And the second part is going to be what is called a living will, which is if there are two qualified physicians tell you that there's no realistic hope of recovery, that you will always remain vegetative, comatose, permanently unconscious. Do you want heroic and life saving measures, or do you want them to withdraw treatment? Together, when you do a healthcare power and a living will in a document, it is called an advanced healthcare directive. So, technically, we are talking about the advanced healthcare directive because they are both in the same document. I'm going to go ahead and share my screen. Again, I'm going to bring up Mark Smith's healthcare directive. This is just a cover page. The date will be there for you. So this is part one, which is allowing the agent to make healthcare decisions. You will see that it's, I, Mark Smith, be your name, sound, mind, and body. Hereby want to make this my healthcare power of attorney or healthcare directive, and essentially has the following powers. So to authorize, withdraw, or withdraw medical treatment. Now, again, this is only if you can't do it for yourself. The biggest distinction between the financial power of attorney and the medical power of attorney is that if the financial power of attorney, if the agent has the document authorizing the agent, the person, as the person with authority, they can do it, even if you have capacity, which is why we keep the document protected, which is why we don't allow the document to float out in the ether. And we don't want people to have it in case something occurs that they're desperate. With a healthcare power of attorney, they will always look to you first. They're always going to want to know what you think. The doctor is never going to take a word from an agent if they think that you have the ability to make a decision for yourself. So that is the single biggest difference. And ultimately, if you want or do not want something, that's what the doctor is going to do, even up to the point of end of life, as long as you have the ability to make those decisions, agreeing to therapy or treatment, hiring and firing of medical personnel, do not resuscitate orders. All of that stuff is stuff that the agent can do for you, take legal action on your behalf. Assuming that you have the authority, you do it. If you don't, then the agent will do it. In this case, of course, we named the wife Sarah Smith, and then we also named Dan and Reese, who are the children in the order named. So it would be Dan and then Reese. With a medical power, you can say and. You can say Dan and Reese. That is not how this one is drafted. In the Blueprint Workshop, we do talk about that fact that you can say and if you want to. With medical, just not financial. And then there's the HIPAA language here, the Health Insurance Portability and Accountability Act. Fun fact, one of my first jobs in law school, in my third year, I worked for a large law firm nationally, and I wrote all of the HIPAA PowerPoints, speeches, and kind of language that got put out when it came out in, I don't know, it was that was the act of 96, but most of that stuff was occurring in like 97 and 98. So I know the act very familiarly. I'm extremely familiar with it, but essentially it just allows your agent to get healthcare information that would technically be a violation of HIPAA, except for the fact that you're granting authority and allowing them to do it. Now, part two. The one thing I want to stop and remind you of is this does not come into effect until two qualified physicians put in writing that there is no realistic hope of recovery. You will always remain vegetative, comatose, permanently unconscious. There's no realistic hope that you will come out of that. The one thing I can tell you from 20 years of experience and case after case after case after case is that if a doctor can keep you alive, they're going to, for a lot of reasons. Probably the number one reason is that's their job, right? Is to keep us alive. Two, I think that the other big reason is because they can only be sued if you're not alive. Of course, lawyers and doctors don't have a great relationship. I'm not part of that because I don't do litigation, so they don't hate me in any way. But certainly, the distaste for lawyers is real. So, as a general rule, they're going to keep you alive as long as they possibly can, because only at the point where you're not alive can they be sued. As long as you're alive, the most you can do is file an injunction to have them withdraw treatment, which is what they would prefer. So, my experience is that they don't look at these. Um, 90% of the time, it takes us begging them to pay attention to it. And usually it's after months of someone laying there in a vegetative comatose state. So this isn't something that they're going to rush to. This isn't something that you have to worry about. Yes, you hear the 1 in a billion horror stories, but I'm telling you, that's 1 in a billion. And yet, if you check any box here that you want heroic and life-saving measures, they will do everything to keep you alive as long as possible, because again, they can't be sued. The other reason is they only get paid when people are alive and they're treating, right? And the best patient in a hospital is one who can't talk back. And so, from a business perspective, it also makes complete sense to keep people alive. I mean, they do not want to lose the patients that are getting paid for simply because they're rushing to make something that doesn't happen in real life. Um, you want to give this some thought. This isn't something that you want to sign without having given some thought to it. So you're going to go one of two ways, right? So this only kicks in if you're in that permanent unconsciousness vegetative state. Two doctors say that there's no realistic hope of recovery. And then it's going to say, by initialing below, I either want nutrition, food, and hydration through a tube in my nose, stomach, intestines, arteries, or veins if I'm in end stage medical condition. Remember, none of this kicks in until you're end stage medical. If you're in that state and there's no realistic hope of recovery, do you want heroic and life-saving measures? So this first initial box is going to be, yes, I want tube feedings, or no, I do not. And then it goes on to say, keep me comfortable, but withdraw all life-prolonging procedures or use all medical treatment necessary to keep me alive. In that second box, again, it's very, very basic. You're saying, give me everything to keep me alive, or you know what? Just keep me comfortable. Give me pain meds, but let me pass away. Don't give me life prolonging measures. Again, only if you're end stage medical. Two doctors, no realistic hope of recovery. The next section, my agent must follow my instructions, or these instructions are merely guidance. My advice, make them follow your instructions. This is what allows them to not feel like they pulled the plug on mom, or they killed mom or dad, or this is them knowing that this is what you wanted. Trust me, if they don't think that you're in that state and they think that a doctor is rushing, all they have to do is say, I'm going to sue you if you withdraw treatment, and they will not. I promise you, they're not going to take that. They're looking for every reason to keep you alive. But if you say it's merely guidance, my experience is that people feel as though they have to make the decision, and then they feel as though they killed mom or dad or spouse, or whatever. So my advice, tell them they have to follow the instructions. If something crazy happens that they don't feel that it's ready, they just threaten, and trust me, they will not withdraw treatment. The next section here is basically anatomical gifts. So I always tell people, look at your ID. Are you an organ donor, or are you not an organ donor? If you are, I would say I do want. If you are not, I would say I do not want. My advice is to match your ID. You don't typically want to have contradictory things floating out there. You want to keep it consistent. That way, there is no misunderstanding and that your wishes are followed through. And then ultimately, the legal protection paragraph is just saying, that agents can act in good faith and that they won't be held liable. And the healthcare people who are relying on the agent can't be held liable either, as long as they have the authority and they act in good faith as well. And then you'll sign below, we'll witness, and then we'll notarize. So that is essentially all that we have here on this document. Again, this is the Advanced Healthcare Directive. The first part was the making healthcare decisions. The second part was the living will, which is end of life decisions. I'd recommend coming in with some idea of what you're looking for. If you have any questions, certainly on the one-to-one attorney review meeting, you can ask the attorney his or her opinion, or certainly feel free to do your own thought process and talk to your family. But ultimately, those are all that will need to be signed when we do the signing meeting. Um, in my mind, just make one decision, right? I either want heroic and life-saving measures or I do not. And if you do, then you will initial the boxes that say that you do. And if you do not, initial the boxes that say do not. Keep it consistent. And then as far as the organ donation goes, keep that consistent with your ID as well. I hope that this video helped in regards to the healthcare power of attorney. I look forward to seeing you on the next signing video. Thank you.